welcome to today's podcast. We're going to be talking about a very exciting topic that we hear from a lot of people about, which is that intersection between living with a chronic condition and workplace challenges and building your career. And we are super lucky because today we have not one, but two amazing guests with us. We have Paige Sparks, who is a labor Hi, Paige. A labor and employment attorney and fellow millennial. And then we also have Dr. Sarah Diekman, who is a longtime YMyHealth contributor now, which is hard to believe. It's been like, I feel like 2 years maybe or something. But um, she specializes in treating POTS patients and long COVID, and also is a POTS patient herself, and just brings such a wealth of experience uh, to us, and is also the sponsor of our Why My Health podcast as well. So we are very fortunate to have you both with us today. Welcome to the podcast.
Thank you for having me.
Yeah.
You're so welcome. Excited for you both to be here. Well, I want to start with Paige first. Um, you know, when you were in law school and you were trying to decide what area of law to pursue, what made you decide to pursue a career in employment law, and what would you like people to know about this incredibly important area of law?
I decided to go for employment law. It's actually a funny story. I couldn't find anywhere else to work. Like I was working somewhere. I kind of fell into it. The first case I had, well, let me back up. The first job I had during law school at a law firm worked for this like crazy lady. She was very hostile, volatile,
Mm.
and I don't have a filter. So one day I did back to her what she was doing to me, and I was promptly fired. And after I what to do. So I applied everywhere. I was trying to get a job at any law firm just so I could have something on my resume because I had already missed the on-campus interviews for other firms. And I found this one that kind of did a little bit of everything, but did mostly employment law. And I jumped in. It was super interesting to me. I love being able to help people who have not only been wrong, usually in employment law, like the scales are so shifted against the employee. So you're the underdog, got to claw your way up. And so I had a really exciting case firsthand, and I was like, this is what I want to do. So eventually I just decided that is only what I'm going to do. And what I think people should know about it is there is a lot of misinformation out there. There are a lot of myths that companies and employers have put out there from decades that people still believe. Like there are people who still believe you can't sue an employer in an at-will employment state, and that is just not true. So what I want people to know is what you've heard may not be true, and that's kind of why I do legal videos, is to correct that misinformation.
Yeah, no, you do amazing legal videos, and I forgot to mention that in the beginning. On your Instagram page, you have such a great presence, and you break down topics so they're really understandable, and like things that are just, even things that are out in the press and things that people are seeing, just it's really helpful to see. And I know Sarah also is an attorney, and I think Sarah, you may have had something that you wanted to say in response to that. I could tell.
Well, no, technically I'm not an attorney because I have not sat for the bar, but I am a JD. Um,
Yeah.
so
It's like the
I,
same thing.
It's the same. I was like, let's not get too technical. No, that's the same thing. You went to school for a long time. Go on.
but I just want to ask this question for our audience because I think
Yeah,
that everyone uses these words synonymously. Can you explain the difference between labor and employment law? So if people are
great
looking
question.
for an attorney, they know what they're looking for.
Yeah, and so this is something I do in my videos a lot where I will sometimes use like the common layman term when it's not how like we as attorneys will refer to things like
Yeah.
wrongful termination. You don't file a lawsuit for a wrongful termination, it's for retaliation or things like that.
Yeah.
So the thing with the semantics, but typically labor attorneys do more with like either union works or benefits or things like that that fall under the National Labor Relations Board and kind of in that realm. And then employment, which I try to stay out of the labor realm. That is not a welcome place for me. I try to stay with employment. So like discrimination that's illegal or retaliation, like if you report sexual harassment and then you're fired, and they can be related in a lot of cases. In fact, do have claims where you may have been sexually harassed and you may not be being paid correctly. There's just different claims. And I think that's why people kind of use them interchangeably, is because it's the same world. It's just different hats.
That's really helpful to hear as we break, because it's two different areas, but similar in different, it sounds like, in how they connect together.
You as an
Yeah,
expert can probably recognize, like, maybe someone came to me for this, but probably they need to be referred to someone else, which is part of expertise.
absolutely.
Yeah,
Absolutely.
we're pay stubs, and I'm like, wait a minute, what do you mean? What do you mean you're not being? So then we can kind of find more claims that way sometimes too. But yeah, it's all under
Interesting.
umbrella. It's just different attorneys will do different things. Like I don't do any straight union work, but I will get you to the National Labor Relations Board investigator. I like
Mhm.
that for you. I have
Yeah.
connections, but I definitely like to stay in my lane.
Understandably so. Understandably so. And when it comes to like clients who are in their 20s, their 30s, early 40s, fellow millennials who have come to you for legal services, what would you say are some of the most common things that they've sought your help for?
One of the most common things that I think more of my millennial clients ask for are like,
Yeah.
we're not afraid to ask for accommodations, especially for invisible disabilities. Unfortunately, a lot
Yes.
of employers don't take this seriously. A lot of employers don't think depression can be a disability when it is under the ADA, depending on how it affects your life. So I actually love to see it because we're a little more feisty of a generation, and even younger generations get like this a little bit more, I see. But most
Wow.
millennials aren't afraid to stand up for their accommodations, or if they're pushed off and they don't get that once they request them, if they don't do the interactive process and find out what other alternative accommodations may be available, for example, the millennials raise a stink about it. And so I see a lot of those claims more so. But it's not isolated to one thing. Certainly, discrimination
Sure.
doesn't know any certain age. I also see some people will come to me. This is, again, misinformation. Age
Sure.
discrimination, at least in my state, and I'm not aware of any federal law that states otherwise, but you have to be like over 40. A lot of millennials don't know that. So there may be other ways that the claims can present, but we're kind of like cut off from that protected class. And so most of them are going to be like disability discrimination for failure to accommodate. And I see it a lot with invisible disabilities, like I said, like depression, ADHD. Those are things you can request accommodations for.
Wow, that's extremely interesting because I was going to say, like, it almost makes me think about far as different healthcare tests, total different subject but related, that are not offered to millennials. You have to be over 40. So it's interesting on the legal side of things for
That
protection
is.
that I never knew that. That's a lot of people are going to find that very interesting. Thank you so much for sharing that with
Yeah,
us.
states that have like a younger cutoff, but federally it's between 40 and 69 years old.
Wow. Very, very interesting. Very interesting. Well, we were extremely fortunate to get connected to you through Dr. Diekman, and I, have had the opportunity to spend some time, as I was mentioning earlier, on your Instagram page, and Sarah. It's so good. And so one thing we were both curious, like, because I mean, the videos are really good, they're super informative, they're super engaging. What made you decide to go beyond all of, and I'm sure you have a huge workload in your daily, employment law practice, and serve the public in this capacity too, to like develop the, kind of this presence and showcase content related to different challenges that people are facing?
It started off by I needed to bring in cases during the pandemic. Like when everyone went
Mm,
quarantine lockdown, I'm like, how the heck am I going to get cases through the door? And so I
yeah,
was like, we have very strict rules of no soliciting, and we have very strict rules to
sure.
follow. I never wanted to be like a call me if you slip and fall, kind of thing. That's just not. So I
Better call
started,
Saul.
yeah, I know though. That's like my favorite lawyer show, but that's just not my, you know what I mean? Like if you put the information out there, you don't have to solicit. People will come to you and ask you for help when you talk as an authority on any topic. And so with the videos, like if you scroll all the way back on mine, they were kind of cringy, I think. And it was just like, hi, my name is Paige and these are your rights. And so it started that way. And then I really took off because I was one of the few first legal creators that would answer questions. And I, of course, have the disclaimer that this is
Sure.
informational, not legal advice. But I would respond if someone would comment and be like, what do I do if my boss won't do this after I requested accommodations? I would generally answer that question. Or I think it would be like rewarding for some of these people. They had no idea they had a case. Like a failure to accommodate for no reason for a long time is discrimination, depending on the circumstances. And a lot of people wouldn't know that. They'd be like, I've been waiting for accommodation for 6 months. And so it's really rewarding to me to be able to help people. And then like the little selfish part of it too is I'm kind of like Tinkerbell. Like if you clap for me and comment and you want more, like I'll give you what you want. Okay. So people ask you questions. I love the Q&A. That's what made it take off. But really, I do just like to help people. Now it'll be like in my day-to-day work, if I'm like, I'll do a consultation with someone and I'll be like, man, I wish I could have gone back in time and told them, don't quit, wait until this part. And so that's kind of how the videos have formed, or I'll talk about cases, but I just try to give people what they want, what they're interested in now.
It's awesome. It really, really is. And so smart to have decided to go on there and develop that, because that's where so many people are. And they're looking for information across the board, and why we went on there as well. So it's awesome because there's so many different specialties that can lend themselves to it that I think people don't realize.
If people would share their knowledge, like just doing informational videos helps so many people.
100%.
Well, the corporations have for years had information being put out on their behalf. It's almost like a PR war.
Yeah.
But with information in it. And, so they've had PR piece, but they're like planted informational pieces and newspapers.
And things like that. Yes.
Yeah. The McDonald's coffee.
Oh, don't get me started. Poor Stella.
Right. Which was a terrible, we all heard that like, oh, of course, coffee's hot. What a whiny baby. She had like 3rd-degree burns.
Right.
Yeah.
Yeah. And needed to like have grafts on her genitals. Like that's not the way they presented it when they did these little PR pieces. So
true.
The antidote for that. You're the opposite side of the story.
Definitely.
Yeah, I love that. And when I don't feel like doing it, I try to think like that. And I'll be like, someone needs to hear this. I've never chased the views. If you're going to make content, you can't care about your views. Someone out there needs to hear what you have to say. And so whether my video gets 200 views or 2 million, I put it out there for it to do its thing.
Yeah. Yeah. No, absolutely. And it's wonderful that you do that, and so, so greatly appreciated. I know I've enjoyed watching many of them and learned a lot. So thank you. Thank you for that. And for us, like at YMyHealth, we're a health resource that is produced, for and by millennials. We also are out there for our Gen Z, who have joined us as well. And, we have, so many people who I'd say, at least 50%, I was thinking about this, at least 50% of our content has really been created or on top, different topics where it's in relation to chronic conditions, all different kinds of chronic conditions in this age group, because there's such a perception that no one who, to your point about invisible disability, that nobody who, looks fine in whoever's eyes could possibly have any health condition that they're dealing with. And that is something that a lot of millennials have to deal with. And so I was thinking a lot about this, and, because we want always to kind of give, every millennial a voice and let them feel seen and feel heard. And that's a big part of this and talking with you both today. But at the same time, in addition to having people in this age group who are living with a chronic condition, we also have our healthcare professional audience, like Sarah, who are RCMAs dealing with the same generational challenges, but they also have their own health to worry about as well as they're trying to build their career in the healthcare industry. And so, I want us to kind of start on that end as well, as we're talking about kind of addressing these different challenges, is, for healthcare professionals, kind of looking at some of the questions that have come from our community that Sarah and I have also talked about, as they're kind of trying to look at patients' rights in the workplace while trying to also maintain their rights in the workplace. So I'm gonna turn it over to Sarah for a moment here, as well. So today Sarah is a guest and a co-host. Yes, because we really want to get, your perspective from her experience in the medical field.
There's a few hills that I'm willing to die on, and the health of healthcare workers being the health of patients is one of those hills that I'm willing to die on. I do think that we cannot have healthy patients until we have healthy healthcare workers. And one of these things that's directly in this intersection here comes with patient staffing ratios. So it's something that I've been aware of having worked in hospitals, but then I've also seen legislations go up for votes and usually get voted down, talking in the voice of as if it's a workers' right thing, but I think that probably was the opposite way. So staff.
Probably actually.
You're right. Yeah, they're like, oh, the freedom to choose how many patients you'll have. We're so glad this cap got voted down. And like, I've never seen a physician or a nurse really empowered to choose how many patients they have. So that sounds like some propaganda to me. And it has just really, I think, just year over year, when I talk to some of the nurses who were working in the 70s, they talk about how in the ICU, it would be like two nurses to one patient. And now that is at the very least flipped. And you'll see nurses in the ED being asked to take care of 50 patients, ratios.
Wow.
So, and physicians, same thing. So they'll show up to work and they're not making the schedule. They're not making these ratios, but at the same time, if they make a mistake, that is usually on them. So yeah, any comments or path forwards, things we should be advocating for as a healthcare community?
I wish there was federal legislation for like mandatory patient to nurse or patient staff ratios. And until we get there, unfortunately, I think the best thing that people can do is CYA with the paper trail. I mean, from working in the hospital, if it's not in the chart, it doesn't exist. And when we hear about these headlines, like, I can't remember her name right now, but the nurse who was being like criminally charged for giving the wrong medication. And but when we're seeing cases like this, they're sensationalized, but that's where they come from people being spread too thin. The ratios are off. We see lobbyists push this and like you were saying, like, oh no, it's like the hot coffee, but for hospitals. Like, this is for your own good.
Yeah.
Like, they don't get the freedom. That's an illusion. Number one. And number two is, no, I want patient safety. I want my nurse to not have to go cry in the broom closet because she's got the whole floor by herself. And I'd rather have, like you said, a healthy, happy nurse that can handle the work. I think it would actually be better for people in that scenario. But until we get federal mandatory minimums or requirements for that, I think the best thing you can do is CYA and do that in your patient charts. Obviously, like, there's a way in a language you can do it for our nurses who are working and they may be short staffed. Put that in the chart. Put why it took you 15 minutes to get that medication. Obviously, don't share different patient information in different charts. You can't do that, but pad that in there. And I'm thinking of this as my like litigation lawyer brain. God forbid something does happen and you get hauled in a deposition 3 years ago that you don't remember who that person was, what day it is, or whatever. You have it now in your chart. Oh, this is why I gave it 30 minutes late, is because it was 1 to 20 on the floor, and it was just like really CYA with the paper trail until we get litigation to protect you. That's like the best thing I think you can do.
I have a follow-up question because I know what the hospital administrator's next move is.
Yeah, they don't like.
I'm not going to write it down. They're going to say, oh, so-and-so, can I have a meeting with you? Right. And then they're going to say, I saw you noted this in the chart. Like, don't do that.
So this is when I think it's important to talk with a lawyer. But if someone in that called me and talked with me, we would then send a CYA email. Hi, so-and-so, I'm following up to this conversation we had today where you asked me not to include pertinent client patient information in the chart.
Oh, that's awesome.
I do think it's important for the care that they know this. These are the reasons why. Let me know if we need to discuss this further or if you still want me to omit patient health information from their chart. And I think that might take care of that problem. And again, talk with a lawyer, because every situation is different. Because if what you're reporting is unlawful, for example, then it could be a whistleblower complaint, and you want to make sure the wording is right. But when in doubt, CYA, double down with more paperwork, because they can't deny it exists when you follow up to the conversations like that. But again, check with the lawyer, because every situation is different. But don't back down. If they tell you not to put it in the chart, put that they told you not to put it in the chart. That's what I would do.
Love it. Beautiful.
Yes, yes, absolutely. I love it. I love it too. I love it too. But yeah, no, very, very helpful information.
Uh, we've been seeing a lot of unionization in the last few years. I think there was in residencies. Nurses have been unionizing for a while in different states. The residencies, I think, have one main union chapter that's been going around, and we've seen a lot of that rise since COVID. I think there's always some talking points or fears out there about joining unions. People are really afraid of the downsides. What are your kind of general thoughts and unionizing in healthcare in general?
I am pro union when we're, especially in industries like this, where you have more power in numbers. That's just how it is. And you have to use what is beneficial to you at the time. So there again is a lot of misinformation about unions out there. It's historical PR spin against it. We've all been told unions are bad, they take your dues and don't do anything. Until you need them and you're part of a union, and then they sue your employer for you. They have their place for sure. Is it the end all be all? No. Are there problems with unions? Yes, of course. But you can also pursue union matters in a private avenue as well. Like I have clients that have a case where whatever happened to them, the termination was in violation of the collective bargaining agreement. So they are bringing a claim. And then also, I think it was an unlawful termination because they reported discrimination before they were fired, and then they have two claims. So it doesn't have to be one or the other. You still have all your other legal protections that apply. However, you have power in numbers when you can collectively bargain for better working conditions or a raise or patient staffing ratios if you can bargain for that. Like there are so many things you can do when instead of being like a little fish in a big pond, when you are a school of fish, that you can organize and do things. And again, there's a lot of misinformation. I get every day, I'll get emails of, hey, my employer said that if we unionize or if we do this anymore, this will happen. They can't discourage that at all. That's against the Labor Relations Act. They can't discourage it. They can't even suggest to you that you shouldn't join a union. And a lot of employers violate those rules. They also have to have union rules posted. A lot of lawyers don't care and they don't post them. So it really may be surprising to a lot of workers to learn what is a violation under the act. Most surprising to me when I was first learning about it is you're allowed to complain about work. It's considered concerted activity. If you complain about your working conditions with your coworkers, they can't write you up for that. They also can't write you up for something and tell you not to talk about it with other employees or that it's confidential. That's also a violation. There are so many violations employers do day to day under the National Labor Relations Act that don't get reported. There are so many free resources for anyone who wants to look online on the NLRB website. So many things like that fall under that, and then you can use it as a protection. And I know I'm like ranting, but when you do have a claim like that,
it's great.
When you have a claim like that, the NLRB will pick it up and do all the work for you. You don't even have to have a lawyer. I think it makes things easier to kind of consolidate your claims and coordinate things if you can find one. But you don't need one. Once you file a charge, they do all the legwork. They'll tell you if you have a case or not, and then they actually litigate it. I had a case earlier last year. They had a for-cause finding. The employer fired my client for talking about pay with his coworkers because he found out he was being paid significantly less than other coworkers, even though he'd been there longer. He was training people that were getting paid more than him. So when he
union, were they already in a union?
No, this wasn't a union, but they didn't have any of the union paperwork they were required to post. So when the NLRB got involved, they pretty much put the hammer down on them. They have a conciliation process where they have to offer him his job back. They have to pay him lost wages damages. They have to announce a letter that got put on the company poster board, they had to send us a picture of saying, "We're sorry, so and so, we will never do this again. All employees need to know you are allowed to talk about your pay at work." Like, they will come after them for you, and you don't need a lawyer to do it.
That's kind of my favorite parts of and the Labor Relations Act is the shaming of when the employer has done wrong, that they have to post it.
And rub their nose in it. Yeah, for sure. And a lot of my clients get an apology. Certainly they don't get a job offer back. And that's the benefit under the act, is like, they'll go fight for you. And if they find that the employer violated it, they don't just, kind of like the EEOC sometimes will be like, "You may have been wronged. Here, you can go sue on your own," and find out the NLRB does not mess around. They are literally like, "You're wrong. Here's the hearing. Everyone appear. And by the way, you have to do these 12 things because you were wrong."
Wow. No, that's phenomenal. I'm going to put the link to that in the show notes as well, to the NLRB. I'll look up. Yeah.
Yeah. Legal resource. It gives examples of other types of cases. A lot of people don't know.
Yeah. And question, just to clarify, because you've pretty much said it, but like, there are some rights that people have before a union has actually been formed. So don't miss out on it. They can violate the act even if there is no union that has officially yet been formed.
That's so important to share. And I'm so that 100% true. The client I was just talking about wasn't in a union. There is no union. You still have rights under the act.
Yeah. That's one of the coolest parts about
That's
it.
that's very cool. No, that's awesome. That's awesome. And then, Sarah, was there anything else?
You know what? I'm going to tell a little story at the beginning of this question. So there's a recent case in the news. Y'all can look it up, that I think tells a lot of what goes on with healthcare and how the safety of healthcare workers is treated, where a patient attacked and hospitalized, and I think may have killed or either seriously injured the healthcare worker. And the CEO, or well, some executive is on the phone with 911, and they're asking how the person is who was attacked. And he's like, "Who cares? Like, we're not worried about that person. That we just are worried about this patient." And that really sums up how healthcare workers are treated. And we're often told, like, this is essential. Like, basically, you have to give up all your bodily safety for patients. And especially because patients are sick, they can, spit on you, kick you, racial slurs, assault you, whatever. And that's just the way it is. So, Attorney Sparks, is that just the way it is?
No, I think that's more misinformation. So the hospital, what they allow, or whatever healthcare provider, what they allow, what they condone discrimination if it falls under that bucket. Like, for example, what you were just saying, if you have a patient that is racially attacking you day in and day out, report discrimination, document it, and ask to be switched to someone else. Like, you do not have to be forced to work in an environment like that, especially if it's like attacks like that, or if it's dangerous where you're being spit on. In a lot of states, that's assault. And especially if they're sick, it can even be escalated if it's something contagious that you can get through the exchange of those bodily fluids. So again, I know we've been all taught, don't say discrimination, don't report these things. These are dangerous words. They're going to fire you. They might fire you anyway. Wouldn't you rather that you had made that complaint before and opposed what was going on? Unfortunately, with a lot of employers, you are just a number. You're there to get them money and make the ends meet. And like the example you just said, honestly, I'm not surprised that that executive said that, because that's how they view a lot of healthcare workers. There's a reason why then they were telling all the nurses, "You're essential" during the COVID pandemic, and then they gave them pizza parties instead of raises. They do not care. And that's just how it is. So at the end of the day, you've got to do what's right for you. Some of those situations you were saying in your example are not unlawful activity. So definitely, like I said, check with a lawyer, because there are ways we can phrase things for like safety concerns or other violations where it can apply some protections. But if someone is sexually harassed, if a patient is sexually harassing you or racially harassing you or anything like that, reporting it as discrimination puts the hospital on notice, which we just talked about they don't want to be. Put it in writing, put them on notice, and it should be taken care of. You are not there to be abused. There are things that you can do to fix the situation or at least protect yourself.
Mm. No, that's very, very helpful to hear. Very helpful to hear. Well, I want to switch gears a little bit now to talk about, more on also on the chronic condition side and obviously protecting your rights as an employee, but outside of the healthcare industry. And there's so many parallels as I'm listening to both of you talk, just across the board, and so many things that people in our age group face. And, the first thing I wanted to know is kind of, Paige, what are your tips for learning how to recognize employers or organizations that are inclusive of people who are living with disabilities, or whether that, is in relation to chronic illness or not, when we're applying for jobs? Because that's something everyone I talk to is trying to you're like, you go into an organization and you're trying to see, do I see any red flags before I take this, in terms of that? Because each one of us is, has something different health profile, different things that we would each be concerned about.
So the first things I would do if I was concerned about an employer not being inclusive of me for a disability, for example, in Missouri, we have a public case record. It's called Missouri Case. A lot of states have a similar system. Look up the name of your employer or prospective employer and see if they've been sued before. If they have a lot of discrimination lawsuits, that might tip you off that they don't care if you file a lawsuit. They're not going to accommodate. There's 12. There's a local hospital that has quite literally hundreds. They don't care. I think you can also tell if they're constantly hiring or have a lot of turnover. While they might not be just related to a disability, that's a red flag for someone that has an open position always, because they can't keep its staff because nobody wants to work there because they're awful. So those are things that, like, when I would be looking, I'd look on Glassdoor, look on Indeed, read reviews. Sometimes disgruntled employees will go leave a review on Google about why they hated their boss or what they didn't do. You can get a lot of insight by doing kind of like investigation through that way, what's just publicly accessible. And then about the application, what I wanted to say, there is always a box. Check this box if you have a disability that you want accommodations for on a lot of job applications. There is no legal requirement to disclose a disability, and you don't have to. You can disclose your disability if you want to request accommodations. But if I had a disability, and I do, if I was applying somewhere, I don't disclose it unless I'm requesting accommodations. That's the only time they need to know. Or if I were to start getting in trouble for something that's a symptom of my disability, maybe then I would put them on notice of it. Until then, they're not required to know. You don't have to disclose that unless you're asking for accommodations. And because of the discriminatory world we live in, I can't tell if someone wasn't hired because they checked that box or not. I wouldn't check it unless you ask for accommodations in writing.
That's very, very interesting, because the list of of disabilities has grown significantly on those applications. And because I've been talking to some people about this recently, because they've taken, specifically for gastrointestinal, they used to just be inflammatory bowel disease, and now they've added irritable bowel. And so we know there are a lot of millennials living with irritable bowel, and they're like, do I check it? Do I not? Because now, who haven't been confronted before with saying like, oh, well, actually, I do have something on this list. I don't know what to do. And people a lot of times don't know, just because even though it says on there, like, this won't affect your potential employment. Yeah. And you're like, okay, well, it's protected. They're just collecting data. So that's very helpful to know.
And let me just give you an example too. Like,
Yeah,
if we have
absolutely.
job applicants, using your IBS example, and one of them filled the application, they're qualified, they check they have a disability, IBS, they're called for one interview, not any after that. I can't really prove why they weren't hired. Okay, if we have some same qualifications, fills it out, doesn't disclose a disability, it's not lying. You're just not disclosing it if you don't need accommodations. They get interviewed. Maybe they get a soft job offer. Then they say, by the way, I do need these accommodations for my disability. And then they're not hired. That's a way different scenario. And they're kind of locked in because you've made it through the gauntlet,
Very, very interesting. Yeah, no, that's very different and great way to think about this too. As you're trying to decide to put on there and whether or not to check the box
Yeah.
with this.
And
Yeah,
even
Sarah, you were gonna say
which of the three, right? Yes, no, or don't want to answer, right?
So I can't tell people what to select. What I will say is a
something.
disability, any physical or mental condition, which you can request accommodations for at any time, depending on how it affects your life. So the day you fill out that box, maybe your disability is not substantially affecting your life.
That day. Yeah.
3 months later, if you need accommodation, because now it is, you can request those accommodations. Just because you don't check that box on the application doesn't mean you cannot request accommodations later. And in
Hmm.
fact, that if I were applying somewhere, I would not check it, and I wouldn't do the prefer not to disclose, and I would disclose it if I needed to request accommodations, just so you're not getting pre-screened out for having a disability.
Because I feel like the preferred not to disclose is going to be viewed like a yes. So,
Or certainly, a red flag to an employer that's looking.
Right.
yeah,
Yeah.
yeah. And disability, the health conditions wax and wane. So
Yep.
True.
things happen.
True. True. Very, very, very true. And for, a lot of people we're talking about far as accommodations, at first, like it can be really nerve-wracking to request accommodations if you haven't done that before, from your employer. What are some ways that people can go about requesting accommodations?
So if anyone's going to request accommodations, I always strongly recommend that they do it in writing, so you can prove that you did it, and
Mhm.
then you have a record of when you put the company on notice for a need to accommodate you. If you are requesting accommodations and put it in writing, it doesn't have to be fancy. You don't have to put it into ChatGPT to make it sound like pompous gurgle.
Mm-hmm.
Literally, it can say hi to your HR and your manager. Hi, I have a disability of this. I am requesting these accommodations. These are the reasons, is because it would help me do this, this, and this more efficiently. I can still do all of my essential job duties. Key phrase, I can still do
Yeah.
all of my essential job duties with and without the accommodations, but these accommodations would help me do it more easily. And then the burden
Mm-hmm.
is on the company to engage in that interactive process to see if they can accommodate what you requested or if they can provide an alternative. A lot of people misunderstand, just because you ask to work from home doesn't mean the company has to let you do it, but they do need to interact with you to see what other accommodations are available if they're not going to give you what you asked for. And so the two most important, well, actually the three most important things, I would request it in writing. You can do your position with and without accommodations. It just helps you do it more easily. And then the third thing is be ready for them not to give you what you asked for, and be open to alternatives. Because what I see a lot of people do wrong, and they get like high and mighty about it, and they'll be wrong, and the employee will be like, I want the accommodation to work from home. These are the reasons why it helps my disability. Suck it. And you can't do that. Like, you have to, they get to respond to you and say, well, we might not let you be able to work from home, but we can offer you flex times on days that you have doctor's appointment. Like, they have to respond and work with you, but you don't always get what you ask for. And I think that's where a lot of people go wrong, because they'll kind of double down on that. The employee, I've seen that happen before. And you don't want to be painted out to look like that if you might be being discriminated against, because it hurts your credibility if you do have a case. So my recommendation, put it in writing. We're asking, not telling. You can still do all of your essential job duties, and be open to that collaborative, interactive process that the company should instigate.
Really appreciate that. And Sarah, you were gonna
Yeah, yeah,
say
I've got
something? Yeah.
a follow-up question. So I do a lot of accommodation paperwork and letters and stuff. And the way these companies will make people feel is like they'll give them this form, and that the company, are not on the hook until someone fills out these forms the correct way. My understanding is this is us engaging in like that interactive process, not necessarily that the company is off the hook if we didn't fill out the form perfectly, because like essentially they were on notice about the disability and the request, just not in their special format that they wanted it.
So again, you want to put them on notice. I would request it in writing. You have to cooperate with the company if you want the accommodations. So if they require you to fill it out printed on blue paper, you do have to do that to comply
Okay.
with the
Okay.
but they cannot use that as a reason to delay an accommodation. What I see happen a lot is these hospitals, like a nurse asks for an accommodation. They make them fill out the special paperwork that only they require. And it's sent out to a third party claims management like Sedgwick, who then sits on it for 3 months. And again, accommodation for no reason can be discrimination. So if you have something like that where it's getting farmed out, and then you don't, keep your finger on the pulse of that and use your original request email chain to follow up. Again, CYA. Hey, I first requested this on this date. I submitted the paperwork on this date. It's been 3 weeks. I haven't heard back. I feel like this is discrimination because I'm not being accommodated or told any reason why or having any interactive process. That would be the perfect CYA in that example of getting a response. But yeah, the employee does need to comply with employer requirements. I sometimes see a lot of people will request an accommodation and then they don't want to provide medical paperwork either. Like, the employer gets to ask questions if you open that door. So don't self-diagnose and say you need accommodations if you don't have the medical documentation to support it. And don't be surprised if that's not accommodated. But housing it out like that or requiring different paperwork, sometimes I see that as like a deflection tactic to delay request. Just keep following it up on your email chain, because like you said, they're put on notice. It doesn't make them off the hook for not having to accommodate. It's just kind of more moving parts that an employee needs to keep track of to make sure they're not being discriminated against.
Excellent points. And what should we kind of have on our radar to make sure our rights are being protected in the workplace? And what should kind of our first steps be if we think we're experiencing violations? Because I know some places have like a dedicated office within HR that handles like a dedicated like ADA office and things like that, but other places don't. It's just a general HR. So what are kind of some of those first steps that we should take? Because I think that's the hardest part too, if we think we're experiencing a violation.
I know it's scary if someone feels like they're in that situation, but the first step, like I said, is you have to document it. If it's not documented, it's not happening. And I know it's scary. We've been taught not to use those words, like I mentioned earlier. And, a lot of lawyers like me offer free consultations. It doesn't hurt to check with someone in your state, let them know what's happening. Like, I write complaints for people to make so that they know what legal language, just so that they're protected. It doesn't have to be rocket science. It doesn't have to be fancy. And that's the kind of your first line of defense is CYA, document it, and go from there, I think. And then don't be afraid to use benefits, like especially in the medical world. I see nurses will request FMLA. This is one of my favorite protections people can have, whether you need it or not. If you have a condition that is covered by FMLA, get it and use it intermittently as you need it, because then you have it when you need it and you won't have to jump through hoops to get it if you have a condition that is covered. I see a lot of hospitals push back for like telling nurses they need to schedule their FMLA and things like that. And that's not how it works. So personally, for me, that's step number 2. Make sure you already have any protections that you can ask for, whether it's asking for accommodations or getting an FMLA under your belt if you need it. Those kind of preventative steps will help you if, God forbid, a situation does arise. I'd rather someone come to me and I'm like, okay, you had FMLA for that leave they fired you for, and you reported discrimination in writing 3 weeks before. Great, let's hit the ground running. Versus someone who believes the employer propaganda, was afraid to say anything so they didn't, and now they come to me and I have nothing to point to other than they fired you for whatever reason they make up. So those are preventative steps that a lot of employees, not just healthcare, anyone can take. But I see it happen a lot where the employer won't honor the FMLA and they come to me and they're glad they had it because they have significantly more legal options because they had those added layers of protection.
Absolutely. And just before you, Sarah, I was going to say, just to remind everybody what FMLA is. So Family Medical Leave Act. Yeah. Just in case. Yeah. Just always try to do as far as the acronyms. Yeah. But go ahead, Sarah. You were going to.
Yeah. So, but let's post that link.
Yes.
This was a question that I had all going through law school and it never got answered. So
Oh no.
No, I don't think it's a gotcha. I think you know because
Paige is preparing.
I'm
trying to
trying to be
get
going.
because it happens all the time in healthcare, right? They give you these like ghost sick days, right? Like you have 10 sick days a year, and the expectation is that you'll use none of them, or they will, I mean, they'll fire you over using them. So I get confused as what someone should do if they have, say, a chronic condition, like an FMLA qualifying condition, and they have not exhausted their contracted for sick day.
Mm,
What? Because FMLA is not paid, right? But the
Correct.
contracted sick days are. So I think you get my
mm.
question. What happens?
Yes, I know.
Yeah.
Yay. Okay. So, by the way, some states do offer paid FMLA companion leave, like Washington State
Whoa.
offers paid FMLA equivalent that you can take at the same time as your federal FMLA. So some states do provide paid leave, most don't. You can get paid on short-term disability at the same time as FMLA for some situations, depending on the health condition. But to answer your question more specifically, to use FMLA, which I think if you have a condition that qualifies, you should get it and just have it if you need to use it. But to use it, you do have to exhaust any PTO and sick time you use first. However, there
Mm.
in the legal world, it's not separated. So like once you have FMLA, you have FMLA because you have to exhaust that time first. So if you get fired after using number 2 of the ghost state you had mentioned, but you also have FMLA, I can still go after them for FMLA interference and retaliation because you had it.
Okay, so apply for it even if you haven't exhausted your sick days, and even if you're not even dipping into that time yet, you can still get FMLA. Uh-huh. Okay.
Yeah. So
Awesome.
That's a great.
intermittent FMLA for you to use as needed. And that's
Mhm.
why you're eligible and you have a qualifying condition, get it. If you don't use it, great. And if you do use it and they create a problem out of it, now there are significantly more things that I can do
Wow.
versus you just get fired because you used a sick day and you didn't have FMLA.
Oh, that's going to help a lot of people.
Yes, it is. I was gonna say that is a pearl of a piece of information. Like, absolutely,
Good.
absolutely. No, super. Oh wow, that I know. We need a moment to just think about that, Sarah. You and I are like, that's awesome, Paige.
Good.
I know that. Oh, what a difference. Well. Speaking of, again, incredible pieces of information. One of the things that I get asked a lot is about different resources to turn to. And I know we've talked about some today, but aside from Ask Jan, which Sarah taught me about, and we have posted a bunch of times about, and it's an incredible resource. Are there other things for people, living with and working with a disability or a chronic illness, that are experiencing, a violation of their rights in the workplace? What are some of the go-to resources in addition to AskJan that they should turn to?
Ask Jan is a great resource and it's kind of like the golden standard of like layman's
Yeah.
terms, breaking things down. And so I'm not aware of any like other equivalent to that level of explanation of things. But there are a lot of things, like a lot of law firms put out legal blogs that educate you on your legal rights.
Mm.
Like Google your question and results like that may pop up that'll kind of reveal what rights you may have in that situation. But in addition to just kind of general searching like that, other websites that we've even mentioned today, like on the EEOC or the National Labor Relations Board website, they publish new findings or opinions or cases they're filing. So sometimes people can use that as a way to be like, hey, that also happened to me. I didn't know I had a case. Or if you go to the EEOC website, they have so many frequently asked questions section of information on how to request accommodations, suggestions on what to say, like how long to wait for a response and things like that. There, as of today, I don't know when you guys are going to post this and what the current administration will take down or not, but as of today, there are tons of resources like that on the EEOC website where someone has asked your question before and you can find out kind of information that can point you toward finding out more information or even hiring a lawyer.
That's awesome. That's incredibly helpful because I think that's probably one of our top questions in this space is where do I go? I have this happening. Where do I even start and where do I go? In addition to all the other phenomenal information you provided, just to even have those sources that are online and even to think about taking, which is a great idea, putting your question in Google and finding out where it goes. Like a lot of people probably would not think about that. So that's really, really, really helpful
Or
too.
blogs, like people who don't do videos like me usually do blogs. And so like
Mhm.
the and will plug in your question with the same blog that'll pop up, which may give you a little bit of information about the rights associated with the question you have. So yeah, I would do a little bit of research like that, read legal blogs like that, because they're out there, the information's out there. You don't have to reinvent the wheel, but sometimes you have to look for it a little bit, and there are plenty of free resources available online.
Oh, that's awesome. Incredibly appreciated. Well, Attorney Paige Sparks and Dr. Sarah Diekman, this has been the most awesome conversation. I'm so glad that both of you could take the time out of your very busy schedules to join us. And I know everyone in the YMyHealth community is going to really appreciate this because so many people, and I know with each of us, as we're talking about just personally, like have dealt at different times with different challenges in the workplace and, come across others, people who are friends, obviously with you, Paige, clients, and with Sarah with patients, who are dealing with these things and navigating the road of that, can be even more challenging. And it's just nice to know that there are resources out there, that there are people who understand and people who have the expertise to help us along the way.
Thanks for having me, and thanks for letting me talk about my favorite things to nerd out on. And yeah, if you learn nothing else from listening, get FMLA. Just do it. Like, it'll help you later. That's my final takeaway. Thank you for having
I love that. You're so welcome. You're so welcome. And Sarah.
Oh, I'm just so grateful that Paige showed up. I'm like body
me.
nerding out. I'm a super fan all the way. So I'm so excited the healthcare and patient community gets to benefit from her expertise.
Likewise, likewise. Well, thank you both so much. This was awesome. And sorry, Paige, you were going to say something.
Oh, you guys making me blush. Like, no, thank you for words.
You're so welcome.